Good evening. Welcome to the Community Awareness Committee's February panel discussion. Our topic this evening is Cobb County's accountability courts. I am Trish Steiner, Chair of the Community Awareness Committee. For those of you who are joining us for the first time, the Community Awareness Committee is a committee of the Neighborhood Safety Commission. The Neighborhood Safety Commission is comprised of 15 individuals who are appointed by the chairman and the district commissioner. We welcome and thank you for attending this evening, and welcome those of you who are watching on Cobb TV. Our committee members are Pearl Roberts and Joel Cope. We have file cards available for written questions. Please turn your cell phones off or on silent, as your phone will interfere with the broadcasting of this discussion. Thank you. Our moderator this evening is Kim McCoy, Director of the Victims Witness Unit, Office of the District Attorney. We especially want to thank Kim for being our phenomenal moderator, and Kim will now introduce our panel members to you. Thank you.
Good evening. Thank you, Trish, and thank you so much to all of our wonderful panel members that are here this evening. We're so very excited to have such a group of distinguished representatives of our community, of our court system, and of the different programs and options that are available to Cobb County citizens and other people in our community. So if you don't mind, I would ask your indulgence and ask each of you to just take a few minutes to introduce yourself, where you work, what program you represent, and then just your elevator speech about your individual programs. So we will start with you, Alicia.
Hi, good evening. My name is Alicia Markle. I'm the program coordinator for Family Treatment Court at Cobb County Juvenile Court. Our program is an accountability court that deals with dependency cases where substance abuse is involved. So we serve the parents and children in those cases. We use our local community agencies through the Community Service Board to treat those clients, and the program is approximately 18 months long.
I'm Christy Garrett. I'm with the Superior Court of Cobb County. I am the treatment coordinator of the accountability courts. We have 3 in the Superior Court. We have a drug court, we have a mental health court, and we have a veterans treatment court. I'm also a licensed counselor, and so I oversee all the treatment for the 3 courts.
My name is Flynn Brody. I am the coordinator for the Veterans Court. I serve as an assistant solicitor general under Barry Morgan. When I first came to Cobb County, I moved over to the Veterans Court in April. Our Veterans Court is determined to take the vets that have gotten in trouble with the law and to find those solutions that help them to be better citizens, whether those solutions be substance abuse treatment, mental health treatment, things that are reflected from their military service. We attempt to take those veterans, get them the treatment they need, and once again bring them back to Cobb County as productive citizens.
Good evening. My name is Judge Marsha Lake, and I work for Cobb County State Court. I am implementing a new behavioral court, accountability court in the state court, and it's going to be designed to identify and respond to the needs of adults that have mental health issues as well as co-occurring issues. Our whole goal is to divert the individuals with mental health issues away from the jails and into treatment, and we are well on our way to implementing this brand new program. Thank you.
My name is Eric Bruton, and I'm also a judge in the State Court of Cobb County, and I work with the DUI court program, and it is an accountability court where it's a post-conviction program where we, when you become a part of this program, you've at least been convicted twice of DUI, and it is a program to, again, hopefully rehabilitate and put people back in society where they no longer have an addiction or can at least conquer their addiction and function as great citizens of our county.
My name is Melody Clayton. I'm a judge at the State Court of Cobb County, and I am right now the judge of the DUI court. We began the court 8 years ago, and I have been the judge ever since. Judge Bruton is currently in the process of moving into my position because I'm currently in the process of planning my retirement for the end of this year. So hopefully the two of us this year will work together to make that transition for our participants a smooth one. But we take people with anywhere from 2, the most we've ever had is 10 convictions for DUI, bring them into the court, give them an appropriate sentence of time and then probation, and then spend that time on probation with intensive probation, treatment, contact with the court to make them productive citizens and bring them back to a good status with the community. And also, as opposed to most of the courts, we are cognizant, very cognizant of the fact that we have a public safety component to ours because DUI driving is a dangerous thing for other citizens on the road, and we are very aware of our responsibility in that regard.
Judge.
Hello, I am Kathy Gorell. I work for Cobb County Juvenile Court. I'm the Juvenile Drug Court Coordinator. I work with the juvenile population of high-risk drug and alcohol offenders.
Thank you.
And I'm Kim Swartz. I'm a prosecutor working with our district attorney, Vic Reynolds, and I'm the prosecutor that works with all 3 of our Superior Court felony courts, accountability courts, which are the Drug Court, the Mental Health Court, and the Veterans Court. I'm the person that kind of, for our office, screens the cases to make sure they meet the legal requirements for the program, and then I refer them on to the rest of the team for further screening. Once we accept someone into the program, I'm the person that actually does the plea to get them into the program, and then each week I meet with the team 1 day a week, and we discuss each of the participants, and then each one comes before the court to see what their progress has been in the program. Also, if someone's not successful in the program and they end up being terminated from the program, then I would be the person that would do those hearings. So I work with all 3. We originally had worked very successfully in our office with the drug court, and when Vic Reynolds became the district attorney, he worked with Judge Staley to develop the mental health court, and now with Judge Green to develop the Veterans Court.
Hi, my name's Charlotte Evans. I'm the defense attorney that works at Cobb County Juvenile Court with both of the drug court programs. In the juvenile drug court, I represent the juveniles that have been found to be delinquent and have substance abuse issues. And then in the family court, I represent the parents who are trying to be reunited with their children for their substance abuse issues and helping them get through the treatment program.
Thank you. Again, thank you to each of you for being here and giving of your time and your devotion to obviously what is compassion for each of your programs and each of your courts, and we appreciate you being here with us this evening. And Judge Clayton, congratulations on your pending retirement. We appreciate the many years of service that you have served the citizens of Cobb County, and thank you so much for all of your work.
Thank you.
So I do have some very specific questions about some of the individual programs. And we will kind of move along those as we go along. Anyone who wants to join in, feel free to say, hey, I'd like to add to that, and you're more than welcome to join the discussion. No question is meant to be exclusive of any panel member. And again, the purpose is just to be as educative as we can for our community. So feel free to jump in anytime that you want to jump in. Several of you talked a little bit about the requirements for your program, and I want to delve into those just a little bit more so that we can talk a little bit about those. And I think I'll start with Ms. Schwartz to talk about in felony court, because in the district attorney's office and in the Superior Court accountability courts, you and these programs are dealing with offenders who have been arrested for felony crimes. So tell us a little bit how those offenders qualify for any of the courts, and then we'll talk to each of those court representatives or program representatives about kind of how that plays out.
Okay. Once a person's been charged with a felony crime, either their defense attorney may be aware of our program, or the judge may suggest the program, and they would go through an application process. And then, as I said, we would review the file. We don't take people into the accountability courts that are charged with some of the more serious offenses like murder, armed robbery, rape. Those types of people would not be eligible for this type of a court. But if they are legally eligible, as I said, then their application is considered by the whole team. And that usually involves an assessment to see if they do have a need for substance abuse treatment or mental health treatment. We get input from the sheriff's department about how that person may have behaved in the jail. We get input from everybody on the team, and if we feel like they're an appropriate candidate, then we would work with the defense attorney to come up with a sentence to bring them into the court. It is a voluntary program, so it's got to be something that the defendant is motivated to do and wants to do. With our mental health court and with all our courts, they would need to be legally competent so that they could make a educated decision about participating in the program, because the program does have a lot of requirements for drug screening, for treatment, for court attendance. But the ultimate goal is to correct the underlying problem that may have caused or contributed to the criminal behavior to begin with.
Great. And Flynn or Christy, if you want to talk a little bit about what a program participant might expect if they enter one of your accountability programs.
If a participant were to enter our drug court, and that is our first program, that program was started in 2002, so that is our oldest. Again, they have to voluntarily choose to be in the program, and they have to have a substance abuse problem and be willing to work on that problem. They will be placed into our treatment program. They are not in custody, and they will go through intensive 18 months of treatment. We look at evidence-based treatment. They will be looking at working on really the core of what got them into their drug use. We do a lot of heavy case management. We would help them if they don't have their GED, if they don't have housing. We help with job placement. Whatever it is that is causing a need in their life, then we will work on that during that 18 minimum months. If they're in our mental health court, that program is 18 to 24 months. They would need to have a severe and persistent mental illness. Our typical diagnoses that we look at in those in that category would be a schizophrenia or schizoaffective or bipolar diagnosis. The Community Services Board is our treatment provider, and we would work with our treatment provider for mental health to develop an individualized treatment plan, and that is what they would follow the course of the treatment. They would also be randomly drug screened twice a week. The Superior Court has its own in-house screening laboratory that's where they would come for the drug testing. They have to call a drug screen line every day to see if they've been randomly selected to take a test. And the reason why we drug test our mental health and our drug court, and Flynn will speak about that, is we're looking for general compliance. They have to have a willingness to no longer use drugs of abuse.
And just like Christy was saying, for the Veterans Court, we're sort of a hybrid of both mental and substance abuse. And what we try to do is we try to figure out the problem that the veteran has when he first comes into the program, because mostly that's what's led to their law violations, whether it be the use and possession of marijuana or some kind of cocaine or heroin, or whether their PTSD is manifested in systems of anger and violence. So we try to get that treatment for them so that way we can get to the underlying issues and help them to be better people, better citizens. Just like in drug court and in the mental health court, they're drug screened twice a week. They go to a treatment-based program that's evidence-based, that's supposed to push them through to make them successful. We have a private provider, WestCare, that helps us do that, but we also get most of our treatment, our initial treatment, from the VA. The VA does our substance abuse treatment. They do some of our post-traumatic stress disorder treatment. We use a lot of the resources in the community to help our vets out, because most of the time when they come to us, either they're homeless or they lack jobs, and so we do those things to help them get jobs, get homes, provide for them a stable environment to be better people.
And I want to stay with you for 1 second. Under your program guidelines, what is the definition of a veteran?
Well, a veteran in our program guideline is someone, based on the law, it says someone that has left the service at that time. And for us, they've had to have completed basic training in their initial job training to make them a vet. Because we've actually had someone come to us who didn't complete basic training. He's not technically a vet because he didn't get a chance to serve. But we are a little bit limited, as they have to be out of the service based on the statute itself.
And how would the level or the distinguishment of discharge affect their eligibility?
Normally, we want someone with an honorable discharge or general discharge, someone who's eligible for VA benefits. We have now asked for funds to treat those who are dishonorable discharge, as long as that discharge is reflected on their law violation. If their discharge was because of drug use, their law violation is because of drug use, and they have a dishonorable discharge, we have the funds to take care of those veterans too.
So you still have options, even though there are some eligibility requirements as well?
Yes.
Great. I'm going to switch a little bit to state court and ask the same questions. So whichever one wants to, we can start with Judge Lake if you'd like, about your program eligibility, and then just a little bit about a day in the life of a program participant.
Again, the program eligibility, the participant would be referred to the program either by the defense attorney, by a family member, by the police, or by the Solicitor General. They would obviously have to have committed a crime. And again, state court, we're dealing with crimes that are misdemeanors, punishable by 12 months or less in jail. There are many individuals that are arrested time and time again for nuisance crimes, and they have this repetitive behavior. So their crime has to be linked to a mental diagnosis. If an individual has interest in the program, they would have a diagnosis by a psychiatrist. So there would be a link between what crime was committed and a psychiatric diagnosis. We are working with a provider who would provide the treatment. They would be selected, go into the program, they would receive treatment. And the whole goal here, again, is to reintroduce the individual into the community with better skills than they came into the program with. We're not interested in putting these people back in jail. We're interested in getting them skills where they can get out, they can work, they can get adjusted with the type of medication that they need that works well for them, that they may not have had an opportunity to have gotten a hold of beforehand. So we have high hopes for this program. Now, Superior Court has a mental health program that is a wonderful program. They've been in operation 3 to 4 years. They're doing extremely well.
Great, thank you. Judge Bruton or Judge Clayton, talk about the
I'll let
DUI
Judge Clayton talk
court.
about the qualifications.
Okay. As far as the qualifications to come into the program, a person has to either have 2 DUIs within the last 10 years or 3 or more DUIs lifetime. The average number of DUIs for the participants in our program has been 3. When a person gets into the program, they go through phases. We have 5 phases in our program. In phase 1, the participant is very, very busy in this program. They go to group treatment twice a week. They go to individual once a week. They go to 4 community-based support group meetings per week. They go to family group once a month. And they are in court in front of me every other week, okay? And then in phase 2, they have group 2 times a week. They have community-based support group meetings 3 times a week. And it is a little bit, and then they still have the family group and other things, but it's a little bit fewer and a little bit fewer. Each phase is a little bit less. When they get to phase 4, they come to court once a month instead of every other week. And it is progressively lessened because the point is we want to move them from somebody who is abusing alcohol or drugs and or addicted to alcohol and drugs and not functioning well and therefore a danger to society and not a productive citizen, to when they get finished, which is at least a year later of all of this treatment and intensive accountability, to being a productive member of society. So you've got to move them from intensive supervision to self-sustaining. If they don't make that, then they can be put back in the program. There are sanctions. If you don't do what you're supposed to do, then you're going to be sanctioned. And there are various sanctions, and they're progressive sanctions, so that the first time you commit a sanctionable offense, you'll get a certain amount of punishment. And if you do that again, you'll have more punishment, and it will increase. If it gets to the point that it becomes obvious to us that the person is either not invested in the program and they're not going to put in what it takes, because we can't do it for them, they've got to do it for themselves, then we take action to terminate them. But if it becomes obvious that they cannot do it, no matter how hard they try, then we try to provide other options for them. But they can expect that they're going to be held accountable for what they do. They can also expect that if they do what they're supposed to do, that they will be rewarded for that. They are rewarded, for instance, by the fine is cut in half if they graduate, and their jail time is lower, and other benefits, including the ability to get driving privileges back, closely monitored by me to make sure that they're doing what they're supposed to do, on a regular, routine, evidence-based program. This is not something that we come up with just willy-nilly, and it is not based on some social work type of, we're going to, love these people into being better. It is evidence-based, that based upon the fact that what was tried before just simply doesn't work, and that is, you put them in jail. It doesn't matter how long you put them in jail for. If a person has an addiction problem, the first thing they're going to do when they get out is use, and the next thing they're going to do eventually is commit another crime, and that doesn't work. So this is a system that does.
Thank you, Judge. So, Madam Prosecutor, we've heard that most of the, if not all of the referrals for these Superior Court and State Court accountability courts really are initiated at the prosecution level. And you mentioned earlier some of the crimes that would automatically make someone ineligible for mental health, drug court, or veterans court. Other than those types of crimes, are there other issues or concerns that would disqualify someone from these accountability court programs?
Well, in the drug court, obviously we would try not to have people in the program that were involved in selling drugs or distributing drugs, because it is a program, for people that have addiction problems. We also look at past criminal record to see if we feel like people are going to be cooperative with a community-based program. And as the prosecutor, in each case, we have to review the case and see what's most safe for the public. There are certain people that are too likely to commit new crimes. They're too dangerous to the public in general or to other people in the program to even participate in the program. So those people are screened out. But of the ones that are appropriate for the program, as I said, the idea is for them to be in Cobb County working on the issues that caused them to commit the crime to begin with. One legal requirement I didn't mention before is that everyone is required to live in the county, and that's because we do curfew checks. A deputy will come by and make sure they're where they're supposed to be. They're required to be in the court, come in for drug screening. But I think one of the strengths of these types of programs is that they are designed to protect the public. And we want to do that by changing the underlying behavior so that someone's not out driving drunk, someone's not assaulting their neighbor, that we've gotten to the underlying issue. As Judge Clayton said, you can send someone to prison and they can stay there for a certain period of time, and you know that the public is safe for that period of time, but ultimately they're going to be out in our community again. And if it's somebody with a mental illness that's not being treated and they're not medicated, that's not a safe situation. So we're not just doing this to help the individual, we're also doing it because we feel like it's going to make our community safer.
Great, thank you. So let's switch gears a little bit and talk about juvenile court, the younger members of our society and the caretakers for them. So Alicia, if you would talk a little bit about the qualifications in your area and what a day in the life of that program might look like.
Yes, absolutely. For family court, it actually is involving the adults or the parents of the children. To be in the program, there needs to be some type of, or there has been some type of dependency case through the Department of Family and Children's Services open, along with the suspicion that there is some type of substance abuse in the home. And so once that referral has came through, and many of our referrals come from the judges at the juvenile court as well as DFACS caseworkers, DFACS attorneys, guardian ad litem sometimes make referrals, and so we have a host of people that make those referrals. Once the referral is received, we do a screening assessment through family court to determine if their criminal factors are too risky in bringing them into the program, the severity of any mental illness if it is present, and then determine what needs are for on their substance abuse end. Like I said before, all of our assessments are done locally through the Community Service Board or in-house at the court. We have a family therapist that's on staff, a licensed clinician that can conduct those assessments. And then at that time, our goal is to start the reunification plan for those families. We work with both mothers and fathers. What we have found over the years is that you can't treat one custodian or the other, or you end up putting that sober parent back in the home with a using parent, and that doesn't work. So we attempt to identify the issues with all family members in the home and address all the issues that we can. We work with a lot of outside community agencies in terms of the play therapy that's needed for the younger children. As we all know, in general statement, oftentimes there's trauma and abuse that comes from substance abuse, but especially in these dependency cases. And so we treat the children as well.
Okay. Kathy?
With juvenile court, we basically follow pretty much the same model that you've kind of been hearing from every court, with a little difference because we're dealing with adolescents. And far as
define for us, I'm sorry to interrupt, define for us your age group.
For juvenile drug court, it's different, but for juvenile drug court, we're 15 to 17. In juvenile drug court, the trends seem, we mostly see the older kids in juvenile drug court. Because we normally don't have first offenders in our program. Sometimes we do. It really depends on what type of intervention has been in place before. So most of our referrals come from current kids on probation that are continuing to abuse or use alcohol or drugs, as well as from our our staff family therapists. We have 4 family therapists on staff, and they generate our referrals based on either the probation kids or the kids who are just coming in and being placed on probation. So in juvenile drug court, all of our clients are on probation, currently on probation for 12 to 24 months, because our program, just like most, is 18 to 24 months. We're a phase system as well, where we start in phase 1, which is way more restrictive, house arrest. There's a lot of accountability. In fact, in every phase, there's a lot of supervision from probation. We have 3 probation specialists that supervise the clients in juvenile drug court, as well as when you start in phase 1, they see the judge every week. That we have surveillance officers that see them at night, drug screen them at night, monitor to make sure they're home, see who's in the home. In phase 2, they have a curfew. They see the judge 2 to 3 times a month. In phase 3, it just gets less and less as it kind of follows the same model as the other programs. Probably the biggest difference with juvenile drug court is most of our treatment, we are high accountability as well as a high treatment program, and most of our treatment is done through individual in-home therapy, through contract therapists. We have some in-house therapies. We have different programs within the juvenile court that our participants are able to participate in as well, different social skills groups, psychoeducational groups. All of the drug court kids have an in-home individual therapist. And again, in phase 1, when the need is the greatest, they're seen weekly. There's a framework. However, because it's treatment, the treatment really dictates if they need to be seen more, if they need to be seen less. We let treatment. We function as a team. I think as Christy spoke of, the drug court team meets every week. We meet every week with the judge, our advocate, the prosecutor, the 3 probation specialists. We have a treatment coordinator, and myself, I'm the drug court coordinator. We all sit down every Wednesday at 4:30 and we meet and we talk about every case coming to drug court, what the needs are. We use incentives and sanctions as well as to the incentives obviously to motivate, the sanctions for the accountability piece. So again, we function very much like most of the other models. There's just always a little different take on it when you're dealing with adolescents. We have eligibility criteria. We call it Right Kid, Right Time, Right Program. That way we're catching the high-risk offenders rather than the first-time drug offenders. At Cobb Juvenile Court, we actually have different programs to address the lower-risk offenders. So the youth that are involved in juvenile drug court are way more high risk. They've usually been on probation, have violated their probation from drug or alcohol use 1 or more times. They meet a certain criteria of a higher offender. And again, it could be someone who is a first-time offender, but based on their assessment, they score much higher, at a higher risk level to reoffend, and therefore that's someone we would take into consideration. And just like some of the other courts, we sit down and we staff them all after they're assessed and make a decision as to whether or not they meet the criteria to come into drug court.
Thank you. Charlotte, you've had a little bit of a break. I hope you got your speech ready for us. Talk to us a little bit about your role, because you're an attorney, and in that role you act as an advocate for the juveniles and their parents. So talk to us a little bit about what your role is and how your role intersperses with family and drug court in juvenile court.
Well, I actually have a document that all the participants sign that kind of explains my role for the juvenile drug court. It's a little bit different for the family court because there's no, it doesn't involve criminal records, and additional charges and things like that. Although the family court violations can result in a sanction of contempt finding in jail for a while, but it's a lot more serious when you're talking about juveniles and preserving their records and trying to keep them from moving on to the adult detention system. So I actually talked to them about my role as a defense attorney is that I'm going to make sure that there's no infringement on their constitutional rights. However, if you are violating your probation and not coming home at night when you're supposed to, or if you are continuing to use drugs, there may be a point where you should be sanctioned, and I'm going to agree with the team on that. So they understand that if they get additional charges, then I would either pick up that traditional defense attorney role at that point and deal with their charges, or I would make sure that they had a defense attorney that's 100% dedicated to their delinquent case. But I'm also part of the drug court team, so I have to, kind of sometimes agree that somebody may deserve to have a sanction for improper activity. My role with the family court is much more, I feel like a counselor. I try to keep the team on track of reunification at the earliest possible time. So I try to make sure that if a parent is doing well in treatment, that they're getting increased visitation, and that the court is considering the earliest possible time for reunification, getting custody of the children back at the same time. I have taken the position that Because that program is so long, that's an 18 to 24 month program as well. If we have somebody that's unsuccessful through the family treatment court and they are considering terminating them from that team, because at that point they could lose custody of their children forever through a termination of parental rights, I have pretty well hammered out agreement with my judge that in the cases, if the parents are offering any resistance to the termination, I'm sure that in all of the courts here tonight, they would all agree that there are certain offenders that are going to be more than happy to leave the program. But sometimes you have, for whatever reason, people that don't necessarily want to leave, but the program has decided it's time for the participant to leave. So I get them appointed their own new counsel that can represent their interests, and it gives them a fresh start, and they do the termination proceeding, and then generally in most cases the underlying dependency case would get transferred to a new judge for further rulings. That way they get a new set of eyes, somebody that hasn't been dealing with them on a regular basis through the treatment program to view their case and see whether or not it rises to the level of them losing custody of their children on a permanent basis.
Okay. And Kathy mentioned that the program age for the juvenile court drug court is 15 to 17. What age ranges do you see differently in the clients that you work with?
Well, generally we all know that there's a lot of scientific evidence that, you know, brains aren't fully developed until 24. That's a normal brain. So if you add in drugs, you're only delaying brain development. So in dealing with kids, we've had a couple of kids that have started as young as 14, and they're rarely successful. I think the most success we get are kids that started either 16 or 17. We had a participant that didn't finish until she was 19. So sometimes the starting age is going to be prior to them turning 17, but then it's an 18 to 24 month program. So they may be 18 and a half or 19 before they conclude our program. And I find that the kids that are a little bit older, once they get out of middle school, tend to have a little bit better maturity. Especially, you can have more success with a younger girl than you can have with a younger boy, in my opinion. And I just started my 11th year working with both of the drug courts, so I think that we do better with the older teenagers than we do with the 14 and 15-year-olds.
Okay. And I'm going to go back to Alicia to stay on the juvenile court trend topic for 1 second, because juvenile court obviously sees offenders as young as 12. Is that right?
Yes, I mean, over the years, I've been there quite a while. We've seen them come in as young as 8 for general delinquency cases.
And so does that person's a juvenile, so is it the parent who is seeking the option to participate in the juvenile court accountability courts or the family court?
Well, those cases wouldn't be appropriate for our types of program unless, in my case, there was a dependency case. And typically what we've seen in the past, unless there's a severity level of mental illness where we would screen out through maybe possibly Department of Juvenile Justice on a general juvenile court track, or possibly that there was another track that needed to take place, but they wouldn't be appropriate for either of our programs at that age.
Kathy, same with you.
Yeah, they absolutely would not. Alicia and I, however, do have some crossovers in that we've had several juveniles who were involved in our program in juvenile drug court, and it became very obvious with probation or with a team that the parent coming to juvenile drug court might have some issues with substance abuse. And just like all the other courts, we treat the entire family, especially with adolescents. There is really no point in treating the adolescent who lives in an environment where the environment's broken. The adolescent has no option to then take care of themselves. They are in that home. And so we've had several juveniles where when we see there's a problem, we address that problem with the parents. We do family therapy. They don't just do individual in-home, they also do family. And then from that, the parent actually ends up with a dependency case, and the parent's in family court. So now we have a child in juvenile drug court and an adult parent who's in family court, and we work both the courts together to treat the entire family. And actually, those cases we've had a lot of success with. I sound surprised, but that works really well. So we do have crossover, but it's still with the delinquents. We have had several 14-year-olds in juvenile drug court, and we don't have a lot of success with the younger kids. It's very structured. There's a lot of accountability, and again, best practices shows us that having the adolescent young children and the adolescent older children in the same program is not best practices. So we generally, most of our kids are 15 to 17 and older once they're in the program, and we have a lot more success with the older kids. However, we do have crossover with family court.
Thank you for each of you for all of your explanations. I do want to acknowledge that we are receiving some questions from the audience. I do want to remind the panelists and the audience that the Neighborhood Safety Commission has a commitment to not focus on any specific case or any specific result of a case in our educational panels. Some of the questions that are handed up are case specific, and I will not be addressing those because of the agreement that the panel has with the members of the panel when we ask you to represent each of your programs. So I just want the audience to understand that. We do have a couple of questions about the success rate of programs, about the number of participants. Is there a limit? Is there a program capacity? And then some other questions about is a person ever released? We know there are termination factors that come into play for people failing drug tests or failing counseling programs or things of that nature. Those are a lot of questions kind of thrown at you at one time, but if we can kind of go again around the room and talk about what you're seeing as far as success rates, if you can quantify that, what your program capacity is, and then about what the options are if the participant fails out of the program or just doesn't qualify for the program. Alicia, do you mind if we start with you?
Sure, no, that's fine. We currently have 29 participants comprised of 3 fathers, 26 mothers, and collectively 61 children among that group. Our capacity is 50 participants plus their children. Oftentimes our families are large, having 4 or more children. So when you're treating those 50 participants, you may be treating 100 plus children that may be at risk as well in terms of their needs, aging from infancy on to 18 years of age.
Success?
Success. As of last year's statistics, we had about a 74% success rate. We base recidivism on re-entry to any open defects cases, as well as any new criminal charges, drug-related charges, et cetera, in which we continue keeping that data. Since the interim of the program in 2006, we've had 109 graduates. And I think outside of just keeping their sobriety, it's also a success rate in that they maintain employment and maintain housing, and we try to look at that through some of our alumni. Obviously, alumni is voluntary, so we don't get to speak to a lot of our old graduates or previous graduates. However, we do have a good standing with a lot of our previous participants where we can get feedback from them to try to improve the program and hear some of the success.
And if someone withdraws or is asked to withdraw from the program, do they have a chance to come back?
There has been some instances, yes. Typically, a termination hearing is scheduled. It's not typical at that termination hearing that they necessarily would come in a few instances that has happened. But we have had some repeated offenses where they have came back into the program a second round for treatment. Through our community service board, they have to have a year separation from the program or from community service board in order to get treatment again through the residential side. So we have to wait at least that length of time, but there is the opportunity to come back.
Okay. And Christy, can you talk about those issues with the mental health court and drug court?
Our drug court currently has just under 100 active participants. As we've discussed, there are 5 phases in those. If someone is terminated, they typically in our drug court cannot decide to participate at a later time. Our mental health court, that's more different because you're never free of your diagnosis, and so that would be more on a case-by-case basis. Our mental health court currently has about 15 participants. I'm sorry, let me jump back to our drug court. Our drug court, as I said earlier, it was started in 2002. We have graduated just under 500 individuals. We run their criminal background checks 1 year, 5 year, to look at their felony charges. And our current rate is they're about 73% likely to complete the program. And then they've got about a 15%, if they complete the program, they've got about a 15% chance of coming back into the criminal justice system with a felony. Our mental health court, we had our first graduation this summer, so we are anxious to track those statistics as well. With our mental health court, we, like I said earlier, we use the Community Services Board for our treatment provider, and we make sure that upon graduation or completion of the program, that they have all of the resources to maintain long-term sustainability with their diagnosis, and that would be community support, medications, community support for the family as well. That's a big component. Our drug court has an alumni association, and the alumni is very active to their success, and they work with the active participants. They mentor them, help them out. They do our orientations, things of that such, which help with the long-term sustainability as well.
Great, thank you. Lynn?
With the Veterans Court, we have 25 participants currently. 23 of those are active. We have one that's in custody as part of his original sentence. So he actually hasn't joined the program itself. And then we have one that is, well, I guess we would consider her AWOL. But other than that, our capacity is probably about 40 at the current grant level that we are, 40 participants. When it comes to success, I would say we're very successful. We have not had a graduation as of yet. Our first graduation is scheduled for 1st of April. But we also have not had anybody commit any new crimes since they've been in the program over the past 22 months. And I would say most of our sanctions that we do have for violations aren't criminal related. And so I think that's a good thing. The programs that we have, they bring out the best in the veterans, helping them reestablish themselves. Our main focus is, before we let them graduate, is to make sure that, one, they have stable housing, their treatment is stable, and also that they have a job. And I think we're well on our way to doing that with each and every one of our participants.
Thank you. And Judge Lake?
As stated earlier, the Cobb County Behavioral Health Court is slated to start in the next several weeks. We hope to open with 15 participants. So we don't have any statistics at this point, but we look to Cobb County, the Mental Health Court. Judge Daly's, just like I've said, doing a fine job. And I know that for the public, we've thrown out a lot of terms and talking about sanctions. And I do want to explain to everybody that when we're talking about sanctions, what that means is when a participant in an accountability court does something wrong. This is an accountability. It's more motivational than punitive. The typical court that most individuals would see would be very punitive. But again, accountability courts are all designed, best practices, to motivate the individual. Nobody makes an individual enter into an accountability court. There's always a desire to be there, and the underlying purpose is to motivate the individual to be a better person for the community, which helps public safety, which lowers costs for everyone.
Thank you. Judge Bruton or Judge Clayton?
Well, I'll say a couple words, and I'll let Judge Clayton fill in the gaps. When Judge Clayton started this program back in October of 2008, they had their first graduation in January of 2010, and since that time, there have been a total of 375 people admitted to the program, 253 graduates. We have 79 current members in the program, and the success rate has been, they successfully exited the program 87% of the time. And I would just like to say, and the reason why I really like these accountability court programs, obviously we're very concerned about public safety so that people do not commit crimes again and do not get on, in our case, do not get on the road again and drive under the influence of alcohol. But the thing that is really good about this is that lives are restored to where people can live, can go back to a normal life with their families, can go back to a life that is not filled with addiction. And one of the greatest benefits, and I know Judge Clayton, I can just see how much she enjoys this program, because one of the greatest benefits is that you get to see families and individuals go back to regular, normal lives where they can live fulfilling lives. And that's what's great about all these accountability courts, is we're trying to put people back where they can be successful and do great things. And so because of that, you know, like I said, they're motivated to come into the court, and so the success rate is really, really high, and which is a great thing for our community. I'll let Judge Clayton continue.
As far as the success rate, of the people, the 87% who have successfully completed the program, we have, and we use a 5-year measurement, 5 years out. We have a 5% recidivism rate when measured as people who have had subsequent DUIs. If you try to get comparison statistics for DUIs, it's very difficult, but in looking across the country for these kind of statistics for this type of population, it varies anywhere from in a non-accountability court setting, anywhere from a recidivism rate in the high 20% to 40%. So we're very proud of our 5% recidivism rate. You know, we'd prefer for it to be 0, but you can't really expect that. I think one of your questions was whether or not somebody could come back into the program. We have recently had, I think, a couple of people approved to come back in after graduating and then getting another DUI. That is truly on a case-by-case basis. We have already dealt with that person. We are very familiar with what that person's attitude and behavior was the first time, and we want to know before we bring them back in again why they think they can succeed and what their case is, what kind of case they can make out to us for why we should let them back in. Again, this is a voluntary program, and if they're going to put themselves into it and truly want to better themselves, then we will strongly consider letting them back in. On the other hand, if it just appears that all they're trying to do is avoid jail time, that's not what we're there for. We're not there to help people avoid jail time who are not interested in availing themselves of what we have to offer. So as I think I told you before, some of the statistics, our retention rate is 89%, and the average blood alcohol level of people who come into the program is a 0.197 and I think people know that the legal limit is a 0.08, but even more shocking, the highest blood alcohol level of anybody who ever came into the program is a 0.45. So you have to see that these people who are coming in definitely have severe alcohol problems, because you cannot walk to your car and put the key in and get it started with that kind of blood alcohol level if you haven't developed a serious alcohol problem. And so we're very proud of the statistics that we have, and we're very proud of the program that we have.
Thank you, Judge. Kathy, if you can address the success and the other issues that we've talked about with your participants in juvenile drug court.
I can. Juvenile drug court has been around, it's one of the oldest ones as well. It's been around since 2002. I've been involved with juvenile drug court for the past 4 years. However, Miss Evans down here has been there almost from the beginning, and she's much better with numbers. I can tell you, and I'm going to defer to her in a minute, I can tell you that our recidivism rate, as far as, I mean, our whole goal is to protect the community from the delinquent offenses, as well as not have these children in the adult system when they age out of the juvenile system. And the recidivism rate, as far as when they move into adulthood, is extremely low, off the charts low. Most of the kids that graduate successfully from juvenile drug court, it's a very, very low percentage, ever become involved. We track as well out to 5 years. And within that time, we see a very low percentage that evolve into the adult system. We've had a little under 200 graduations, I believe, in the time that juvenile drug court has been around. Our maximum capacity is around 35. We have a little under 20 right now. That's not necessarily grant-driven. It's really, we've recently changed some of our criteria as far as through training and best practices as far as what the criteria is to come into juvenile drug court, trying to home in on the adolescent that drug court works for, who we can best treat. And we were expecting a lull in the numbers and hope that changes soon. Not hope that there are more children that need us, but hope that we're addressing the issues that they need. We as well, for every drug court kid that we treat their mom, their dad, and their siblings as well. So it's double, triple that number, just like family court. And then I'll just, if you don't mind, defer to Miss Evans for more of the numbers.
I laugh because I went to law school so that I didn't have to deal with numbers at all. But she's correct. We've graduated somewhere between 175 and 200 participants in the time that the drug court has been around for the juvenile drug court. I don't know what the number is for the family court, but it's a pretty impressive number. My whole goal was not just about keeping kids out of the adult criminal justice system, but also, we save the community money in the fact of if a juvenile does not get intervention at a young age, then they will become an adult, a criminal, somebody that has to deal with the adult drug court or, the adult prison system. So that's my whole goal with working with kids, is just trying to keep them from ruining the rest of their lives through getting adult charges. So definitely with our successful participants in the fact that they don't then engage in criminal behavior as adults, we have a great amount of success. And I think that one thing that every court up here could say, that even with the people that aren't successfully completing the programs, we're giving them pieces that they can take away and use later. So it might not be effective while they're with us, but I've had kids that have come back to me on things that I've told them about, if you're young now, and the YDC, they've got video games over there, and they give you Pizza Friday, and they'll do a dance. But you go to the adult detention system, and the only dancing that's going to happen is not anything that you want to be a part of. And I had a kid that turned 17 and then got arrested for a non-drug offense and had to spend the weekend in the adult detention center, and then he because of that new charge, ended up going straight to the youth detention center and came to see me and the judge the following week. And he said, Miss Evans, I know you said it was going to be different. He goes, but I just don't think that there's any way that I realize the total difference about how they treat adults versus juveniles. And so that's why I do what I do, to try to save the county money in the long run. Not necessarily, we're treatment, it costs money, but it costs a lot less to treat a youthful offender than it does to house an adult prisoner for life, you know, because you don't just use drugs, you then engage in other really bad activity. You're breaking into houses, you're robbing stores, you're killing people, you're selling drugs. I mean, you engage in very serious felonious behavior that starts by using a little bit of pot when you're 15 or 16.
Okay. And Ms. Evans, one of the things that you mentioned earlier was that girls were easier to work with in your program.
Oh,
in
no,
the
no,
programs.
no. I
Okay.
said girls are more mature.
Okay.
You might have a little bit better success with a 14 or 15-year-old girl than you will with a 14 or 15-year-old boy, but girls are never easier to work with. Girls are just as bad as the guys are.
Thank you for clarifying
Yeah.
that. And Ms. Schwartz, in the district attorney's office, you have the ability, I mean, you specialize in the accountability courts, but obviously you have the ability to see other cases in the office. Can you give us an idea of, do you see offenders that you might have worked with in the accountability courts back in the criminal justice system?
Usually those people go back to the regular courtroom. We do, if there's a new crime that's committed, we try to deal with it right there in typically drug court. But as has been explained, if somebody is not following the rules of the program, we really try to do everything we can to work with that person. You know, people have used the term sanction, and that can include a few days in jail, that can include community service, that can include the judge having them sit in the jury box and watch court all day. We're really trying to be innovative and creative in mixing up our drug testing, you know, to catch someone if they're still using substances, to explore the medication-assisted therapy. But if it gets to a point where the person's going to be terminated from the program, depending on their criminal history before they came in the program, then they're just going to be sentenced by the judge. If they've never been convicted of a felony, the judge would just give the proper sentence. If it's somebody that we let into the program that had an extensive criminal record and they were able to avoid prison, if they were successful, then the judge is just going to enforce that prison sentence and they're going to go into the Department of Corrections custody. But what we're hoping for is that the way people get out of the program is by graduating. As I said, if they've never had a felony conviction and they're successful in our program, their case is going to be dismissed at the end, which is going to be a huge benefit as far as finding a job later on and so many other things that a felony would disqualify you from. So that's what we're hopeful for. Everybody's kind of given the statistics on the commission of new crimes, but one thing that I really enjoy getting to hear is when people are going to graduate from the program, they're interviewed by the whole team. And we ask for their input on how their lives have changed. And I remember in particular a middle-aged man that was asked, well, how have your family relationships changed? And he said, well, my mother will speak to me again. He said, when I came into this program, my mother wouldn't speak to me. She wouldn't allow me in her home because I stole from her to get drugs. Now I'm gainfully employed. My mother has health issues. I live in the home with her and take care of her. So not only, I think, are we affecting future criminal behavior, but we're also restoring family relationships.
And that's an excellent success story of each of the goals that you've mentioned in rehabilitating, making people a productive member of society, giving them those chances to become healthy and productive and re-enter society in a better way than when they first took advantage of your program. Ms. Schwartz, I'm going to ask you one more question directly. If someone successfully completes one of the accountability court programs and then a year later commits another crime, would they be eligible again for an accountability court option?
I think that would be unusual to have them back in the program because, as I said, this is a big commitment of resources and time. And, you know, we sometimes, you know, ask the question, who's working harder here? Is the team working harder or is the participant working harder? And so I think when we've committed that level of resources to somebody and it hasn't been successful, they may need to go back through the normal criminal process. We have been, since we have the two new programs, Mental Health Court and Veterans Court, we have gotten to a point at times when we say, you know, maybe this person should be considered for the Mental Health Court instead because of some issues that have come to light. We've tried to identify on the front end, this person's applying for drug court, but this person's a veteran. Maybe they could better be served by applying to that program. So we are trying to exercise all our options in the Superior Court to make sure that we're fitting the program with the person.
Okay, thank you. Specifically, I want to ask a couple of questions about Veterans Court and the clients that you and the team works with in Veterans Court. We hear horror stories on the news about how veterans are treated, about services that are withheld from them for a variety of reasons. The goal of your program and all of the programs is to help these people become healthy, productive members of society. In light of the mental health issues that many of those veterans might suffer from, how do you address the mental health issues, the emotional issues, the adjustment issues back into society to really help this veteran become more productive and more healthy?
Well, one of the unique things about Veterans Court is it is focused on accountability. And most soldiers, most military veterans, they're used to that accountability piece of being told what to do, when to do it, and how to do it. And so when they initially come into the program, it's very heavy on accountability. It's, you know, you have to be at your treatment, you have to be at your drug screens, you have to be at court at certain times, you have to meet with the outside provider. Very, very heavy, very intensive. And so they start to develop that sense of family with the program. And that helps a lot with their mental health issues. We send them through mental health treatment through the VA. Sometimes it's good and bad because most of it is all about self-reporting. So as long as they're honest and upfront about what's going on, they can get the treatment that they need. Now, what we do as a team, we can see things and we notice things, and we have an outside provider that can help us do those things that they're not willing to admit to or are afraid to admit to. Most people think that PTSD is always manifested in anger and violence, but that's not always true. Most of it's about depression. And depression comes from, you know, not having a job, not having stable home life, not having family relationships. We can work on those things to get to the root of the problem to help their mental health needs. And what we're finding out is as they go through our different phases, they get stronger and stronger. And our people in phase 4 are ready to go out into the world and be productive citizens to contribute to what the society has to offer for them.
Thank you. Several of you have mentioned the issue of sanctions. When participants are not following program guidelines, rules, regulations, treatment plans that are put into place, the word sanctions has been mentioned several different times. I want to make it clear so that everybody remembers the reason these participants are in one of your programs is because they've been arrested for something or because there is a juvenile delinquent issue or family dependency issue. This is not a community-based volunteer program where someone comes and seeks your services. Everybody agree that we're all on the same page? Right. Okay. So even with that in mind, they're there because they've committed a crime or juvenile court is addressing some issue. There are some who might say that a sanction can be demoralizing and degrading and can deflate someone's ability to achieve based on the fact that that sanction is put into place. I might ask the coordinators yourselves have you seen that? Can you address that among your program participants?
Well, I think just human nature, anytime someone gets in trouble for something they have done wrong, they may feel embarrassed. And if they feel that embarrassment, that's a good thing because that actually shows that they care. So we can see with that there's a lot to work with. It's those that could do a sanction standing on their head and they don't care. Those are the ones that we're very concerned about. So yes, just human nature. We don't like to do wrong. These individuals in these courts are coming before the judge, and the model is that judge is oftentimes seen as the parental factor, the parental role. And so, you know, just as us as kids, we want to impress our parents and we want to do well. But no, we never have the intention to harm someone. And that's, again, the beauty of these programs. These programs are a multidisciplinary team that we sit at a table on a weekly basis or a biweekly basis, and we all sit down, all disciplines that we've talked about tonight, And we talk about those sanctions. The judge is the ultimate, head of that team and is going to make the decision, but we discuss those things. Sometimes a sanction is to change the behavior, and sometimes we may give a therapeutic response. Sometimes, a therapeutic response may be something that's handled in treatment, and it's to help them learn a different behavior. It may be a paper. It may be a presentation. It may be doing an assignment over. And again, it's not meant to be punitive. It's meant to help change the behavior.
Thank you.
Could I address that for just a second?
Certainly, Judge.
One of the differences about these types of courts over the usual, you've committed a violation, you're going to come before the judge, we're going to have a probation revocation hearing, and if you are found to be in violation, then the judge is going to probably put you in jail. And the judge doesn't know very much about you because the judge sentenced you 4 months ago, 3 years ago, whatever, and hasn't seen you since, and now the prosecutor is bringing evidence that you have violated probation in some way, and the probation officer testifies. Unlike that model, which has been the traditional model, the judge sees you on a routine basis. The judge meets with the team on a routine basis. The judge knows you. You come in front of the judge. I can tell you that there are times that as the judge that's imposing a sanction, I feel like I have felt when my children were small and I had to impose punishment on my children. I never put my children in time out to shame them or make them feel bad because I didn't like my children and I wanted to demoralize them. I did that because I cared about them. There have been times when I have felt the same way, when I have felt the same sense of how am I going to impose the right sanction on this person, to make this person understand that they have to be accountable, but they'll still be able to go on from this sanction and continue on and get it done. And part of it is right on the judge's shoulders to make sure that the participant understands they got to be accountable, but they can do this. Because if we thought they couldn't do this, we wouldn't be doing a sanction. We'd be doing a termination hearing. Or we'd be saying, this person is so sick, this person is so addicted, that our program is not the level of treatment they need. We need to find a different program for them. So we are imposing a sanction that, based on evidence-based practices and based on the specific needs of the individual and the specific offense or infraction that the participant has committed, is appropriate at the time. And that falls with the advice of the team, but it falls directly on the shoulders of the judge.
Thank you, Judge. Flynn, did you want to add anything?
Yes, just like Judge Clayton says and Judge Lake pointed out, sanctions are meant to be motivators. And the unique thing about the accountability courts is, just like Judge Clayton said, is that the judges know the participants. They know everything about them, their family, their mental health history, their criminal history. They know everything about them, and so they've got a unique perspective on how to motivate them to keep them going forward to the place that we want them to be. Most of the time, we start off small with sanctions, and then they move on to bigger things, and that's only just to get that message across. And normally, for all participants, the sanctions are very heavy when they initially come into the program. But as they move on through the program, through the different phases, and understand what we expect of them and how to make better of themselves, they seem to get minimalized. And the thing I love about accountability courts is just the fact that the judges have that personal relationship with each and every participant.
Thank you.
If I could add to that too, one thing we haven't talked about as much, but we also have incentives, and so when the person comes before the judge every week, they're going to be commended if they're doing well in the program. The judge might say, I've heard that you really exercised leadership in this group last week. As they tell the judge how their week's been and that maybe they got a new job or something positive happened in their life, the whole group is going to celebrate with them. And, it's unusual because you're going to be in a courtroom setting and people are going to be clapping, but they're clapping because somebody's been sober for 9 months or somebody's gotten a job. So that's the flip side of it, is that hopefully we're also encouraging people in that manner.
Right.
And Kim, one other thing is, accountability courts are unique in that when someone gets sanctioned, the rest of the participants rally around them to tell them, hey, it's all right, you're going to be okay. You're going to get past this and you're going to become better for it.
Great, thank you. So the community that you are creating with each of your accountability courts not only helps with the incentives, but it also helps help people press on when they're facing tough times. And I see that with the members coming in and out of the courthouse frequently. So thank you for pointing that out. I'm going to take the liberty to answer this question. The question specifically asks if someone is not eligible for an accountability court, or if there is just a need in the community. Are there resources in the community that can help? And I know each of you are shaking your head because we all know that Cobb County is wealthy in the resources that we have, in a lot of the nonprofit areas that we have, and a lot of the service programs that we have. And so if anyone in the audience or the listening audience or viewing audience has a specific question about a resource, they're welcome to call the Victim Witness Unit. Probably any member of the panel can point someone in the direction of a right resource if those resources are not met through the program's participants in the accountability courts. We are just about at 10 minutes, so I want to kind of bring everything to a close so that Trish can bring us out. The last thing I want to close with is asking, several of you mentioned the word mentor or volunteers. So if you could take just a second and talk about, do you use mentors and volunteers, and how are they helpful to your program participants? Alicia, I'm sorry, we'll start with you.
Sure. We actually do use, as I mentioned earlier, some of our alumni, much like Christine mentioned in Adult Drug Court, as help for our early phase participants. And so we have had success in those mentors.
Thank you.
In our adult drug court, those that are active in our Phase 5 treatment, they are paired up with a Phase 1 participant, because we have found that if you just put all the Phase 1 participants together all the time, that's the blind leading the blind. They need to see success. They need to see the light at the end of the tunnel, because sometimes that can be very difficult. We are asking really just one thing of these people in this program, and that's generally to change everything about their life. And that's very overwhelming. And so having someone who has been there, done that, got the shirt to prove it, is very valuable and helpful. The Council of Substance Abuse in Georgia has a program called CARES, and that they look at mental health and substance abuse. And so they do trainings for individuals that have been through this, and then they turn around and like to put them in volunteer programs like these, or employ them. And so our mental health court program actually uses that program. We have a peer support specialist on our team that acts hand in hand and actually does some of the case management and social services groups with them, because it is very helpful. It's like talking to a teenager. Sometimes we can say it till we're blue in the face, but if that peer is right there beside them, sometimes they listen to them better.
Thank you.
For the Veterans Court, that's probably the strength of our program, is our mentor program. And just to give them a plug, if there's any veterans out there that are interested in this, we'd love for you to come and apply to be a mentor. Our mentors go through a mentor boot camp. There's one here in the state of Georgia. There's one that's done nationally each year. Basically, they're paired up one-to-one, a mentor and a mentee. We try to match them service to service. So an Army vet will get an Army mentor. Also, we try to do combat veterans. If you've been to combat, we try to get you a mentor that's been to combat also. Someone that you can actually talk to who understands what you're going through and you can look at as a model for your success. We do interview all our mentors. We do background checks on them to make sure that they're appropriate for the program. And we've had great success with our mentors. They take ownership to the fact that they've even got their own website and have started a 501c to help our mentees. So the mentor program is very strong here in Cobb County.
Thank you.
The Behavioral Court has had no graduates yet, but we do plan on relying very heavily on mentors as they do graduate and volunteers. And for the public, there are several graduations that are coming up, and if you've never seen an accountability graduation, it's a sight to behold. The DUI is having a graduation coming up, I believe, in March. We've heard that the Veterans Court is going to have one in April, and you will get to see the community environment of how an individual goes through a program. They work so hard. These people are with each other for a year or 2 years at the most, and they graduate and they've succeeded in life and they're well on their way and they're open to the public. And please get with us afterwards and we can let you know of when the graduations are coming up. We would love to have you come.
I want to defer to Judge Clayton on the mentors, because I know she is very familiar with that.
We have several avenues for that. One is we require every participant from the beginning of the program to have a sponsor in their community-based support group and to document to us that they have a sponsor, and that's a person that's experienced with sobriety. That's not necessarily a person that's been involved in an accountability court, though it can be. In addition to that, we have an alumni program that is very active, and our later phase participants mentor our earlier phase participants. So we try to do it on several levels and in several ways to make sure that our participants know from the beginning and throughout the program that it can be done, it has been done, and that they can do it.
Thank you, Judge. Kathy?
Well, mentoring is probably the biggest hurdle for our population. I think probably way more so than the adult population. Again, you're dealing with children, and so do you have an adolescent mentor an adolescent? Do you have an adult offender or previous offender mentor someone else's child? We really struggle in this area. We are always looking for a mentoring program that can meet the criteria, because there is just such a high level of liability when you're dealing with a juvenile population. And you know, we're not the parents of these children. These juveniles are on probation, their parents are not. And so that just brings on a whole nother liability issue. This is a big hurdle. I am always welcome to new ideas. We are always looking for any type of mentorship program available in Cobb County that would be willing to take on our population. We do have our older Phase 5 kids that have already graduated and they're still finishing out their aftercare, come back to juvenile drug court, and of course all the delinquents in our program participate in every graduation, so they get to see that big celebration of the Phase 5 kids when they're graduating, and it really is a big community thing. And you know, it goes from the kid who came in hating life and hating everybody to hugging the judge and hugging all of us because we're all friends and close and we're parents. So we do have that. However, the individual mentorship where you match up one person with another, that's a struggle with our juvenile population.
And it just may not be appropriate for that type.
In many ways,
of
it is
court.
not.
So, okay. Well, believe it or not, we are out of time. So as your panel moderator, thank you very much for all of you participating this evening. Thank you for the service that you provide in our community. Thank you to the Neighborhood Safety Commission for sponsoring our community awareness panels, and I will turn it over to the Neighborhood Safety Commission to close us out.
Thank you, Kim. Thank you for attending and watching on COB TV this evening. We especially want to thank our dynamic and distinguished panel members and moderator. We are honored to have each of you as our moderator and panel member this evening. Our community is very fortunate to have each of you educating and providing information to the community concerning the state superior and accountability courts in Cobb. We are very fortunate to have the drug, mental health, veterans, behavioral, and juvenile courts in Cobb County. We commend you as judges, attorneys, and court personnel for your daily dedication to ensure that individuals receive the opportunity to enter one of these court programs. You are truly changing the future of many individuals who would never have the opportunity to get help and support to positively change their lives. You are appreciated, and we thank you for your daily service to the citizens of Cobb. We want to thank our District Attorney, Vic Reynolds, for expanding and supporting these accountability courts. A special thank you to Cornelius for broadcasting us on COB TV tonight. Thank you for joining us this evening. We invite you to watch all of our 2013, 2014, 2015, and 2016 panel discussions on COB TV or link from the Neighborhood Safety Commission. Please join us Wednesday, March the 16th at 7 p.m. when our topic will be animal control. Thank you so much. Good night.